Okay, welcome to the League of Women Voters Lunch and Learn for Salina, Kansas, for Tuesday, January 10th, 2023. And the League of Women Voters is a not-for-profit organization, nonpartisan, that encourages participation in government and civic discussions. And one thing we try to do is get good information out there. So we really appreciate you being here today, and we appreciate anyone who watches this later online. Today we are talking about the Equal Rights Amendment, how it started, what happened to it, and what could happen to it in the future. Our presenter is Anita Specht, Dr. Anita Specht from Kansas Wesleyan University. She is the chair of the history department at Kansas Wesleyan, and she's been there for many years. She said since 1999. So welcome, Dr. Specht.
Well, thanks for asking me here today, and this gave me a chance actually to do some research on the Equal Rights Amendment, which I had not done thoroughly before. So hopefully I can pass on some of the exciting things that I learned to you. One of the things that is surprising, I think, is that about 70% or so of Americans think that we've already got an Equal Rights Amendment, or that men and women are treated equally in the Constitution. And that is, as I found out, quite clearly that's not the case. And that's what we'll see once we get to the end of this presentation. But I wanted you to know a little bit about the background of the Equal Rights Amendment. And let's see if I can hopefully get this to. Yay. Equal Rights Amendment, as most of you know, starts here in the 1920s with this woman, Alice Paul. She was one of the heroines of the 19th Amendment. She was a prominent suffragist, taking the suffrage movement into a new direction, getting younger women on board, being more radical. She was the founder of the National Women's Party, and she's also the person that drafted the Equal Rights Amendment to the Constitution, which went through Congress the first time. The person who championed this first version of the Equal Rights Amendment was a Kansan, a Republican with a very distinguished history. He, as you see here, was the nephew of Susan B. Anthony. He's also the son of Daniel Anthony Sr., who was a prominent figure in the Bleeding Kansas era. He was also a very progressive Republican, and he was the editor of the Leavenworth newspaper, and a very prominent Kansan in his own right. And here is his son, who became a member of the House of Representatives in 1907. He succeeded Charles Curtis. Charles Curtis, a Native American man. He was elected to senator, and that's what allowed Anthony to fill his spot. Curtis later went on to become vice president. In 1923, he picked up Alice Paul's Equal Rights Amendment, and he got it through the Judiciary Committee of the House of Representatives, and got it to the floor of the House of Representatives. And what we see here is the first copy of that first Equal Rights Amendment as it went through the House of Representatives. And the text of it is, the important piece of it, the amendment part of it is down here, stated as Article 20. And that states, men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. Congress shall have power to enforce this article by appropriate legislation. That's the first version of the Equal Rights Amendment. It made it through the House Judiciary Committee, it passed the House of Representatives, and then it stalled out in the Senate for decades and decades. The goal of this amendment, as you can see here, is that there be no legal distinction based on sex in matters of divorce, property, employment, or other matters. That was Alice Paul's objective. And Congressman Anthony's as well, I would assume. This amendment, which to us seems to be so straightforward and simple and have so many positive aspects to it, was actually something that different people felt differently about. And what I've put here on the slide is the reasons why lots of folks were in favor of the ERA and why some are not. The folks that are in favor of the ERA, and these are the justifications that Alice Paul gave, was that a national amendment is necessary to make sure that there's no distinctions among the different states in terms of rights for women. This would provide a uniform blanket, uniform umbrella for women's rights throughout the whole United States, which is something that most of us probably know. She said that we need a national amendment rather than just individual laws because an amendment is a permanent piece of the Constitution. And make sure that this is something that won't change, theoretically, through the course of the decades. She also said that this is a pragmatic political thing to do because we don't want women's efforts split up and divided. Because some women were saying, well, we can just do amendments to state constitutions and get this passed through the various states rather than a national amendment. And Alice Paul said, what that means is that we're going to have women's groups split out among 48 different states, and that just basically divides our efforts. Why don't we unite together again around a national amendment? It's much more effective in terms of or efficient in terms of organizing. She also made the point that what we want with this amendment is to eliminate those things that discriminate against women based on arbitrary standards and stereotypes of gender. That women are weaker, that women are inferior to men in some way, that women are more emotional and therefore they need these special laws regarding their treatment. Alice Paul was somebody who says, no, men and women need to be treated the same in all of these key legal points. The folks that are against the ERA, some of their arguments are here on the other side of the screen. Basically, one of the arguments is that this will change the condition for women. People who discriminate against women, they're going to discriminate against women regardless of the amendment that's in the Constitution. So it's really not going to affect much. The opponents also said that the time, they're kind of making the sufficiency argument as well. Women are going to be spending a lot of their time trying to get the ERA passed when they should be passing laws that are really going to help women and protect women, like getting laws regarding child care, laws regarding workplace safety, and a whole host of things that women need. And if women's groups are devoting their energy to the Equal Rights Amendment, it's going to take away from the time and organizing efforts that we need in order to change the physical conditions that women are facing. And then finally, the main reason why they don't want the ERA is because there are a lot of laws on the books in the 1920s that were protecting women's status in the workplace, that were safeguarding women in ways that the other workplace laws did not. At this time, in 1923, 1925, 1930, there are very few workplace safety laws. There are no minimum wage laws. There's no law about, the 40-hour work week. That's just not part of the American workplace in 1930. But laws have been passed that would say that women are not allowed to work more than 10 hours a day in certain occupations, that women are entitled to a certain minimum wage because of their status as weaker workers, people who aren't as physically strong, and because of their status as mothers. So that puts women into a separate category, therefore they need some special laws that will protect them. But if we get the Equal Rights Amendment, those laws will go away. So, what we see shaking out from 1923 when the first Equal Rights Amendment, goes through the House of Representatives until 1970, we see folks falling on, into both camps in ways that aren't readily predictable to us today. What we see is that, there are Democrats who oppose the ERA, there are Democrats who supported the ERA. There are Republicans who supported the ERA, like Daniel Anthony, and there are Republicans who opposed the ERA. So this was not a partisan issue. And we can see that from the fact that presidents from Eisenhower through Carter supported passing the Equal Rights Act, which is, I think, surprising maybe to some of us today. One of the things that is probably most surprising is that second piece there. Labor leaders consistently oppose the Equal Rights Amendment because of that last bullet on that other slide. The Equal Rights Amendment could take away those protective things that help to shelter women workers. Like, making sure that they aren't exposed to hazardous conditions that male workers might otherwise be exposed to. One of the most famous women politicians and political activists was Frances Perkins. Most of you probably know she was the first woman cabinet member. She was in Franklin Roosevelt's cabinet. She was Secretary of Labor. She did not want the ERA. So there's this very, prominent politician who's a woman, who's active in women's suffrage and all kinds of women's political causes, and she's like, no, we don't need the ERA. It's not going to protect women like they need to be protected. So labor leaders and the AFL, the CIO, all other labor groups, they were for the most part opposed to the ERA. And leads to that last point here, women are divided on this. Women are split about whether to support the ERA. And that starts to change in the 60s. As you know, we see the second wave of feminism coming on board in the 1960s, the women's rights movement, and that's when women started to see the discrimination against them in terms of employment, in terms of equal wages, and in terms of a whole host of other aspects, educational opportunity and so forth. And that generated this new movement for another go, another shot at the Equal Rights Amendment. And that's where this lady comes in, Margaret Griffiths. She was a member of the House of Representatives, a Democrat from Michigan. She is somebody, she was a lawyer, she was a judge. Her husband was very well connected in the Democratic Party structure. So she was from a politically active family. And her point of view is nicely summarized in this quote from her. I don't know really that I have so much perseverance as I do a sense of indignity at the fact that women are not justly treated. So that becomes the new foundation stone for the construction of this next version of the Equal Rights Amendment. She and another House member, Enid Green, were extraordinary parliamentarians, extraordinary politicians, because they worked this amendment into the House vote by bypassing the Judiciary Committee. She and Enid Green worked together to get a discharge petition supported. A discharge petition means that this amendment won't need to first get the approval of the Judiciary Committee. Ordinarily, that's the way an amendment goes. It goes through, it's introduced in the House, it gets referred to committee, Judiciary Committee, and then the Judiciary Committee debates it, polishes it up, and then sends it to the floor of the House for full vote. But usually what happens, or what can happen, is that amendment can get to the Judiciary Committee, and the Judiciary Committee can then stall it out, and then it just dies. So Griffiths and Green, they said, okay, we're going to get a special petition, we're going to make it so that this petition goes through, and it's going to bypass the Judiciary Committee, and it's just going to come right to the floor of the House. So they were able to get 218 House members to sign the petition, and then they got 332 out of 435 House members to vote yes. So this thing was a slam dunk.
What were the numbers again?
It was 218 House members signed the discharge petition, which is extraordinary. Usually the discharge petitions fail. It's only maybe 10% of them will be successful. But they got 218 signatures on that petition, and then the final vote was 332 out of 435 House members. So basically 3/4, 75% of House members said, yes, let's get this ERA through the House. Yep. So, she and her other members of her group were extraordinarily successful politicians, in being able to work this through the House. This is what comes out of the Senate. So the House passes the ERA, sends it over to the Senate, and so the Senate debates. They change some things, and it ends up being passed by the House as well. So this is the final version that gets through. And one of the things about this that is this new ERA amendment, it's been through the House, been through the Senate, it's going to get sent to the states, but it's a little bit different than the first one. One of the things that is different in this joint resolution on this new amendment is here. And this is the sunset provision. So the Senate said, what we want on this amendment is a time limit, basically. So if this thing is not passed by 3/4 of the state legislatures within 7 years from the date of its submission to Congress, which was March 22nd, 1972, which is when the Senate said yes. So if we don't get 3/4 of the states by March 2nd, 1979, this thing's gonna die, I guess. And that's one of the funny quirks about this. That's I'm going to point out in a little bit. Other than that, the meat of the amendment is very similar to the first ERA that was put forward by the House in 1923. What we see is Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So that is the Equal Rights Amendment that we are talking about today, and that people in the 1970s were talking about. The response in the states when the amendment first got out of Congress and got sent to the states in 1972 was a lot of excitement at first. And in fact, there are various states that are jockeying to be the first one to vote yes. And this goes to the state legislatures. State legislatures are voting to endorse this amendment or not, to put this amendment into the Constitution or not. So what we see, by 1977, 35 of the 38 required states had ratified the amendment. Hawaii got the privilege of being the first. They voted yes on that just the day after the resolution passed. And Kansas was not very far behind. Our state voted yes within a week after it passed the Senate, which is, a big testament to our state in 1972.
That's 1972.
1972. I put the vote counts here. Kansas Senate voted 34 to 5 in favor. The House of Representatives in Kansas voted 86 to 37. So, it's just a really strong, vote in favor of the Equal Rights Amendment. What's interesting, though, out of all of these legislators, only 2 were women. Glee Jones and Josephine Youngkin. One a Democrat, one a Republican, and both of them voted no. Which I think would make a fascinating research topic in and of itself, which may be something in the future I will be doing. It's very interesting. Again, what we see here is kind of a bipartisan issue. A Democrat and a Republican both saying no. We have obviously, a lot of Democrats and Republicans saying yes. So, this what we see here is that it's not a litmus test for folks in 1972 until, as you know, Phyllis Schlafly mobilizes folks on this issue. She mobilizes the conservative Republicans around this issue of the Equal Rights Amendment. You can see here her dates, 1924 to 2016. She was a lawyer, a conservative Republican activist. She was a campaigner for Barry Goldwater in 1964. She cut her teeth, I think, in that political campaign. She is somebody who gets incensed about the Equal Rights Amendment, and she gets other women to sympathize with her perspective. She forms the group Stop ERA, and the STOP stands for Stop Taking Our Privileges. So you can see right from the start how she is framing opposition to the Equal Rights Amendment. And it's in a way that is very effective, because who wants their privileges taken? Not me! She must be right. She must be on a valid point. She argues that the Equal Rights Amendment is going to erode gender distinctions. We're not going to know what a man is, what a woman is, and it was one of the privileges it's going to end is husbands' financial support of wives. They're just going to start laying on the couch and making their wives do all the work, I guess. That's what she's already at. Which leads to, all these arguments and and I think the one that most of us are familiar with is the bathroom confirm that, you know, we're gonna have men using women. We just can't. Yep, the last one apparently was from a poster that the Stop ERA group carried on a march. So, I mean, it's just, you know, it's like, this is just, it's just perfect. Yeah, I mean, it doesn't give any way to see a pro-ERA person as being a nice person. I mean, it's just, there's just no way. I mean, either you're evil, or you're communist, or you're homosexual, or you're something horrible that's going to destroy America if you're supporting ERA. So, well, I'm a good person. I want to keep my privileges. So, obviously, this thing is crazy. It's a very, very effective political strategy that she employed. She went on fear. She based things on, you know, religious justifications, and she also hit people's economic fears as well. You know, women will lose alimony. They will be forced to support their husbands. They won't be able to get any privileges from a marriage. And, you know, Phyllis Schlafly is hitting all those concerns that are very, very personal to people. The results are, as you know. You know, what started out as just a wave of support for the Equal Rights Amendment, you know, starts getting rolled back and rolled back and rolled back. And we see that most clearly in 1978 and 1979 when 5 states that had originally approved the Equal Rights Amendment rescinded their ratification. And those states are Idaho, South Dakota, Nebraska, Kentucky, and Tennessee. Congress, you know, was trying to save this thing, and you know, remember that sunset provision? Well, the clock is ticking. So in 1978, Congress passed an extension to that sunset provision. President Carter signed it. But he wasn't sure he should sign it because he didn't know if he had the authority to reauthorize this amendment going out again. He didn't know if it was even right to have a sunset provision on an amendment in the first place. But he signed it, you know, just to make sure that there wouldn't be that legal complication of the president not signing something. Then what we see in 1980, Ronald Reagan as a candidate for president, as a Republican, declared his opposition to the ERA. Ronald Reagan becomes the first president since Eisenhower to say no to the ERA, to an Equal Rights Amendment. And what we see when he does that is really the politicization of this issue. It now became, you know, a partisan litmus test in a way that it had not been. Constitutionally, there's lots of stickiness around this new Equal Rights Amendment. And the issues really are these 3 here about you know, imposing a sunset clause on the amendment in the first place. Is that possible? Can Congress do that? We don't know. It's not specified in the Constitution, but it doesn't seem quite right. Another issue is about the revocation of a ratification by a state. Can that be done? We don't know. It's not been tested. So these are issues that at some point may find their way to the Supreme Court. And then finally, President Carter signing off on the extension of that deadline. Is that even constitutionally proper or allowed? We don't know. There are a lot of reasons why the Equal Rights Amendment is still needed. And these arguments are outlined in Jessica Newworth's book, Equal Means Equal, which is a great resource. I'll have it on the screen here at the end of the presentation. She basically gives a legal history of the last 40 years, 50 years, about the ways that women aren't protected under the 14th Amendment and under the Equal Protection of the Laws clause of the 14th. And it was in ways that are surprising. For example, companies are able to fire pregnant employees or discriminate against pregnant employees. This came forward in a case involving Peggy Young, a UPS employee. On telling her boss that she was pregnant, the boss's response was, "You're too much of a liability in our building. Don't come back until you're no longer pregnant." Peggy lost salary and benefits for 6 months. In 2013, her case was denied by the federal courts because the Pregnancy Discrimination Act was meant only to ensure that female workers would not be treated differently from other employees simply because of their capacity to bear children. So even though there's a law on the books that's supposed to protect pregnant women's rights and abilities to keep their job, that's says it doesn't work in Peggy Young's case. Which, one of the things that I learned by reading that book, Equal Means Equal, is that the way judges can rule on things are very unpredictable. Things that would seem to be obvious decisions, judges can reach a totally different conclusion. So when you're going before a judge or before the court system, it sounds like it's almost just playing Russian roulette, whether your work's going to hit. Another reason why the ERA is needed is that it would prevent companies from hiring, paying, and promoting based on gender stereotypes. And this came to the fore with the case of Stephanie Odell, who was a Walmart employee. She found out that a male in her position made $10,000 more per year. When she complained, the boss said he has a wife and kids to support. And I'm sure that's an argument that some of us have probably heard. In another instance, when she asked the general manager to increase the pay of 2 women employees, he said, "Oh, those girls make enough money." So, Supreme Court Judge Antonin Scalia ruled on this case, so this made it all the way up to the Supreme Court, as Odell sued Walmart over she was trying to get a class action suit against Walmart. And the Supreme Court denied their class action lawsuit against Walmart, saying Walmart did not have an explicit policy of sex discrimination. Even if a statistical pattern of pay discrimination was shown in all 3,400 Walmart stores, women employees still could not enter a class action lawsuit against Walmart. So it's like, whoa. Yeah, and it's because, Walmart is allowing the managers of each store to establish at their discretion salary policies. Who gets paid more and who doesn't. Well, it's because he's supporting a female labor. So we can give him more. And because it's not explicitly listed in the Walmart policies about women must be paid less than men, it's not official. So, but what is happening is that there's gender stereotypes running rampant through these practices, and according to the Supreme Court, there's no way to deal with that. Still. Yeah. One of the most shocking cases to me was this one here. That a restraining order that a woman files, it does not necessarily have to be followed by the police. And that happened in the case of Jessica Linehan, who lost her 3 daughters, Rebecca, Catherine, and Leslie Gonzalez, when her ex-husband kidnapped and killed them, even though she had a restraining order against him. And these were little kids from, I think, 7 to 10 years old. Just heartbreaking. Jessica sued the police department because they weren't enforcing the restraining order. And the Supreme Court in 2004 rejected her claim that her due process rights under the 14th Amendment were violated, saying that the 14th Amendment protects against state action, not individuals' action, which is a very odd, it seems to me, odd way to interpret the 14th Amendment. Jessica Linehan's reaction was, the U.S. Supreme Court said that I had no constitutional right to police protection or enforcement of my restraining order. So if restraining orders are not enforced, then they're not worth the paper they're written on. And that's ultimately what it amounts to. You know, and this is really scary. Really scary. All of this, you know, adds up to, you know, the conclusion that, you know, the 14th Amendment does not necessarily protect against sex-based discrimination. Based on the Supreme Court's interpretations of the 14th Amendment, particularly since 1972, when the court determined its different categorizations of
Protected classes?
protected classes, exactly so. The different levels of protection that are based on race or sex or something. Judge Antonin Scalia, his conclusion was that the Constitution does not prohibit discrimination against women. The Constitution does not prohibit discrimination against women, which is the ultimate reason why the Equal Rights Amendment is necessary if you're going to, you know, try and safeguard equality of rights between women. Where this issue stands today, there's several options. We can go state by state, get all the state constitutions or various state constitutions to pass equal rights amendments in their state constitutions. Let's see here. So far, 22 states now have equal rights amendments in their state constitution. Our neighbor state, Colorado, has one, has a state equal rights amendment. And in Colorado, its court ruled that pregnant women must be covered by their health insurance because of the state's ERA provision. So there are some places in which health insurance will deny coverage to women. And Colorado says, nope, can't do that because it violates our state equal rights amendment.
That just happened a couple of years ago, too.
Was it?
Yeah. Colorado.
Yeah. So, you know, it's just, what surprises me is how these things that I assumed are not an issue, how could they be an issue, are an issue.
No kidding.
Some other options here to, you know, reinvigorating the Equal Rights Amendment are to get Congress to extend the approval deadline again. But it's not clear whether that's allowed under procedural rules. It's not clear whether the original deadline was even allowed under procedural rules. If the deadline is extended, is it just 3 more states that are needed? Or if the deadline is extended, do we need to start the whole process all over again? So there's just all kinds of things that are up in the air with this option. Third option here, start all over again. You know, reintroduce the Equal Rights Amendment, which has been tried in, I think, every session of Congress since 1980, 1983. Senator Ted Kennedy was always a driver behind this movement to try and get another Equal Rights Amendment through Congress again and start the ratification all over. And it just, it always failed, because now it's just really a partisan thing. Yes.
So the Congress is really the only person that can make the decision on how we're going to reinstate the amendment and going through the process.
It could also be done through a convention of the states. So if all the states get together, and I think it's 3/4 of them, say they want to have this equal rights amendment through a state convention, then it can get passed in that way.
Okay.
You know, there's two.
But it's not up to the Supreme Court,
No. It would be up to the Supreme Court to determine like
whether it's
the
constitutional to.
no, whether it's, whether you can extend the deadline.
Okay.
You know, that's something, or, you know, the deadline is passed, and now we're gonna get 3 more states all to sign on. Is that still okay? The Supreme Court would probably decide on that. Yep. So, you know, reintroducing the Equal Rights Amendment, it's just that is a huge uphill battle. Okay. Or there's this other option called the 3-state plan. And remember, you know, we just needed 3 more states to sign on. If we say those 5 states that, you know, bailed, if we say that their action on, you know, rescinding, if we say that wasn't legal, that would have to come to the Supreme Court. We can say that wasn't legal, we can keep those 5 states on board, then we only need 3 more. So we have this 3-state plan. We can get 3 more of those other states that hadn't voted on it to say yes, then we've got our 38 states. And we can get this thing through, can't we? There we go. Yes.
Wouldn't now, with how society's doing things, be a good time to reintroduce it because of the turnout we had this summer in voting? Now, I had women come up to me saying, I didn't know that it was an issue in all this. Because, I mean, if you're just concentrating on going to work and raising your family, that takes a back seat. But wouldn't now be a good time to bring it up again?
It might be a good time to bring it up as a state, as an amendment to our state constitution. It
Oh,
might be-
not federally?
Well, because Kansas has already said yes. Kansas is one of the, you know, 38 states that said yes on the federal amendment.
Oh, okay.
And what has happened over the last couple of years is that we got those 3 states. In 2017, Nevada said yes. 2018, Illinois said yes. And then in 2020, Virginia said yes. So we've got the 3. And now what happens? Well, the thing is, you know, that Congress is saying, well, time's up. Just asked. It's too bad. You guys saw it, said yes, but there's nothing we can do about it. So in January 30th, 2020, Virginia, Illinois, and Nevada filed a lawsuit to get the Equal Rights Amendment placed in the Constitution. January 30th, 2020. February 19th, 2020, Alabama, Louisiana, Nebraska, and South Dakota filed a lawsuit to intervene and to stop that. So then it gets kicked into the federal courts to let the judiciary sort out what the rules are. So that's where we go in June 12th, 2020. The Federal District Court for the District of Columbia agreed to intervene. The DC Circuit Court said, yeah, we'll take a look at this. And on March 5th, 2021, a federal judge ruled that the ratification period expired and the three states' votes came too late. So that was the court's decision on March 5th, 2021.
Which court? This is the DC?
DC Circuit. Yep. So, on May 3rd, 2021, the 3 states filed an appeal. Nevada, Illinois, and Virginia filed an appeal. So then it gets kicked into the Federal Appeals Court for the DC Circuit. in February 2022, Virginia withdrew from that suit. And then on September 28th of 2022, oral arguments were heard in the federal appeals court. And I don't know where it's gone since September 28th, 2022. So my suspicion is that the appeals court will agree with the original decision. That's my guess, if I'm reading the tea leaves right. So, there's just lots of, legal complications surrounding this whole issue. It's fascinating. Fascinating constitutionally, it's fascinating from the perspective of equal rights, but the thing is, there's a lot of people's lives that are caught up in this. And if the police aren't, legally obligated to enforce a protection order, people's lives are at stake.
I don't see how the Equal Rights Amendment would prevent non-enforcement of a protection order.
I'm not sure, as I understand it, the argument is equal protection of the laws. And that's.
Does that mean they have to do it for a man?
Yeah.
Are they doing it for a man?
No, I assume so.
Yeah, but for no
Well,
one. I just guess I don't, I mean, it's shocking, period.
Don't think in domestic violence cases, when there's an arrest, don't both parties get arrested?
Not always.
Not always, but,
I don't know.
okay.
That's a legal question, way beyond my training. Yes,
I took a self-defense class from a retired Salina PD, and he said the PD's stand on it now is they take both of them and arrest them and let the judge sort it out, so they don't get involved in who said, she said, he said.
Okay, that's what I thought.
That's all. At least that's what they're doing. I don't know if that's the rule they're supposed to be doing, but.
Well, and I would think it would depend on the various jurisdictions. I think it would be individually determined.
I also think it depends on the circumstances. If you have a woman lying on the floor and the guy's
Yes,
looking completely
right.
healthy and happy, they probably don't arrest the woman.
Right.
But if they both have been fighting with each other, then they arrest both of them.
So there was one in 311 this morning that they both got arrested.
Yeah.
She was fighting the cops.
Oh.
She was biting the cops. That's smart of her.
Was that the one that bit and kicked?
But what really surprised me when I was reading this book here, I Can Only Is Equal, is how tenuous the rights are for women in this country. And I was one of those 70-some% that thought this is taken care of. We've got we've got Title IX, we've got the Civil Rights Act, we've got all sorts of laws on books that protect equal treatment of women, but those don't necessarily mean that women are going to be protected.
So the
Or
board
gonna get
interviewed
equal rights.
Jessica Newworth.
Uh-huh.
Yeah.
So any other questions? Oh.
What if all the women decided to go on strike for a little bit? Until the laws change.
Well, but part of it is not all women think the same. There's a lot of women out there that are still in the Philschlaffe that say we don't need this. In fact, and would say in fact that it harms women.
And of course, the bathroom argument was won the day on the trans
ridiculous.
kids.
Oh, yeah. You see how powerful that still is.
Well, let's go right in. Thank you. Thank you. And I want to say that for once, I know the upcoming Lunch and Learn, so I can announce that here. The February 14th, Valentine's Day, we're having the topic for Lunch and Learn is Community Resilience Hub, which is a new thing at Kansas Wesleyan with involvement of some other organizations. So that's, should be right here on the 14th of February, Community Resilience Hub. And then on the 14th of March, which is the first Tuesday in March, we're talking about the Electoral College. And Dr. Specht is going to be part of that. And who's the other person?
Dr. Bedros, Andrew Bedros, who teaches sociology and political science at Wesleyan.
Okay, so they will be talking about the Electoral College,
Yep.
and that's another interesting topic.
Yeah, well, and we would like you to come to Kansas Wesleyan.
Yeah.
If that's gonna be convenient. So
We're
it's
holding
something we can
that
talk about.
At Kansas Wesleyan, probably at the student, or the campus center, or not quite sure.
Might be in a classroom.
Might be classroom. Okay, we'll find that out, we'll let you know.
Yeah.
So, thanks so much for coming, and thank you, Janet, for videoing this. All right.
Can you do the Martin Luther King?
Oh, let me say one more thing.
Yeah.
Well, this Saturday and Sunday is Martin Luther King Day celebrations. The actual holidays on Monday, they read the proclamation last Monday. But on Sunday, they're having a citywide celebration at St. John's Lutheran Church. The speaker is Reverend Carl Frazier, pastor of the New Hope and Love Community and board member of the Center of Peace and Justice in Topeka. And on Monday is the noon celebration at St. John's Missionary Baptist Church with youth taking the lead there. And also that evening, 7 p.m., is a celebration at Kansas Wesleyan with speaker Dr. Jennifer Gordon, who is a retired elementary principal from Topeka and secretary, vice president and secretary of the Dunbar School Association, which was the African-American school that opened during segregation times in Salina and closed in 1950s, early 50s. I think that's right. So, thank you again.